Good morning, ladies and gentlemen, and if anyone is using this for homeschooling, good morning, boys and girls. Thank you for joining Phil Fisher's Pensions Monthly webinar. Today, we're going to be talking about cybersecurity essentials for pension schemes. Before we move on to the full content, I'll just run through a couple of housekeeping notes. Firstly, if you have any questions, please use the question stroke chat box, which is in your control panel. Normally, when you use GoToWebinar software, you'll find the control panel on the right-hand side of your screen. If we have questions and comments, we'll aim to get through as many of those as possible during the course of the webinar. If we don't get time to answer all the questions, then our team will follow up with you individually. Secondly, if you have any technical questions or issues, then please use your questions drop down, and we also have our technical team on hand to assist. So if you have any technical questions, again, use the questions or the chat box, and it's just someone else will be picking that up. So I'm delighted to be joined this morning. First of all, sorry, I'm David Gallagher. I'm a head of pensions at Phil Fisher, one of the partners in the Employment, Pensions and Immigration and Compliance Group. And I'll be talking about trustees' governance duties during today's webinar. I'm delighted that we're joined by Natalie Fuhlgraber, who's head of data protection and group data protection officer at Arriva, the major international transport company. And Natalie will be talking about how to implement best practice within pension schemes and using the support of the employers' organisations. And as you can see on the slide, she'll be talking about roles and responsibilities, also how subject access requests are processed, and some of the challenges from 2020 in particular, and how people are adapting to working from home. And then we'll move on to my fellow partner at Phil Fisher, Leonie Power. Leonie specialises in information and privacy law, and she'll be talking about data security and incident response processes and legal duties that trustees and other data controllers have under GDPR. She'll be looking at scheme personal data, security and incident response obligations, and how to go about assessing risk. So in terms of what I wanted to say, just a little bit about how trustees have to operate in a pension scheme, because a pension scheme under UK law is almost always set up under trust. There are some public sector schemes that aren't, but in the private sector, pension schemes are pretty much always set up under trust. And some of you may have seen in the flyer that I was going to say a little bit about what Victorian judges said in the 19th century about cybersecurity. And of course, they can't have been talking about cybersecurity itself, because it wasn't an issue in those days. I think cyber is probably a 21st century word. So what did they say then in the 19th century? Well, the graphic there that you can see is Mr. Justice Chitty. He was one of the most significant judges of the 19th century in terms of the development of a number of areas of law, in particular the law of contract. He was also one of the judges at the forefront of the process of judicial precedent, so whereby the decisions that judges made in cases would be reported and recorded, and would then be used as principles for lawyers to advise their clients as to what legal duties were based on what would happen if you did go to court, rather than actually having to go to court to find out what those duties were. And one of his leading judgments was in a trust case, and was specifically around the duty of trustees to keep confidential information private, to keep it confidential. And he also, in the same case, balanced the need of trustees to keep information confidential with the rights of beneficiaries. So in the pension scheme context, the rights of members to see the information that relates to them and to their own rights. So quite an important case. It's still used in trust law textbooks today, but actually underpins a lot of what we look at in information security, data privacy, and cybersecurity. So fundamentally, trustees have a duty to keep information confidential, but members have a right to see the information that relates to them. It's also fundamentally true that trustees of all trusts, including pension schemes, have a duty to act in the best interests of the beneficiaries. And that includes looking after their interests within the trust, so making sure that they don't lose their rights by, in the 21st century, fraudsters hacking their information and being able to take their benefits or transfer them away, or otherwise divert them into their bank accounts. There has always been a duty on trustees to obey the terms of their trust deed, and a number of trust deeds these days do have specific obligations about confidential information. A small number have obligations specifically about data privacy, but more usually it's about confidential information. And there's always been and always will be a duty on trustees to comply with applicable law. Now, in the context of pension schemes and data security, that means, of course, data protection legislation, GDPR, Data Protection Act, but also the Pensions Act duty to maintain internal controls within a pension scheme. And that's something that I'll turn to now. Apologies, just having a problem with the slides there, sorry. So under the Pensions Act 2004, although it's under the 2004 Act, it actually came in December 2005 by an amendment to that Act. But trustees have a legal duty to establish and operate an effective system of governance, and this includes internal controls. That system must be proportionate to the size, nature, scale, and complexity of the scheme's activities. And important to note there that it is the scheme activities, not the employer. So if you've got a small scheme with a large employer, it's proportionate to that small scheme. But by the same token, if you've got a large scheme with an employer, which these days is small, the duties are still proportionate to the size of the scheme. And size, I think, would look at the number of members as well as the assets and liabilities. I think scale refers there to the value of a member's pension to the rest of their financial income. So for a number of schemes, pension schemes activities are of large scale because the benefits are so important to the members. There is a code of practice specifically on internal controls produced by the pensions regulator, and that recommends that trustees who are responsible for this perform a risk-based review with periodical control reviews, and that they make clear a segregation of duties. And I know that that's something that Natalie's going to cover to show how that might work in practice. Important point here, particularly when we look at a 2020 context, and again, Natalie's going to talk about this in the context of home working, is that risk assessment is a continuous process and it must take account of a changing environment. And if anyone wants to see what a changing environment looks like, then I think 2020 is the year in which you could see that. The regulator also has specific guidance on cybersecurity. This is very similar to their guidance on internal controls, and that's not surprising because it is a similar process. You've got this 1, 2, 3 in the circle, but it's a continuous circle. So it's one where you assess and understand the risk, you put the controls in place, and then you monitor and report. And that evolves as life evolves because you may discover risks because how things have gone wrong will show you what it is that you need to assess and understand in order to come back round and put new controls in place. So you may have a system that works well for a number of years until a threat comes or technology improves or working processes change. Suddenly we've got scheme administrators where everybody's working from home month on month, and that requires the trustees to look at it again, to monitor and report, see how things are working, and then assess and understand the risk. A key point here that's made in the regulator's guidance, and this will be the last point before I hand over to Natalie, is that trustees and others involved in the administration of the scheme should seek appropriate information and guidance on cybersecurity threats. And one of the points the regulator makes here is that actually trustees sharing information with their administrators and with other pension schemes and administrators, sharing information across the industry can be valuable to assessing and understanding the risk that schemes have to deal with, and therefore the controls that they should be putting in place. So on that note, I'm going to pass to Natalie, who's going to talk about cybersecurity and data protection and how to implement best practice. Natalie.
Lovely. Thanks very much, David. It's great to be with you this morning to just provide a little bit of insight into how we're working with our trustees within Ariva. Just to provide a little bit of context, as David said, I'm the Group Data Protection Officer within Ariva, but I actually report to our Chief Information Security Officer. So I work very, very closely with our information security colleagues, so that includes focusing on cybersecurity. So we're a very close-knit unit. So as I'm talking through this, what I'm really talking to you about is, as a team, how we're continuing to work with our trustees to really make sure that they've got the assurance they need in the context of cybersecurity and data protection. If you wouldn't mind moving on, David. Thank you. So the first thing I really wanted to talk about was roles and responsibilities. And one of the things that we're talking to our trustees about at the moment is really ensuring that they have the understanding of where those roles and responsibilities actually sit, and particularly taking into consideration the fact that quite often the supply chain when it comes to delivering the schemes can be quite complex. And what we've done in the first instance is really look at producing a RACI. So some of you, most of you will probably be quite familiar with a RACI, but essentially it's a matrix which you can use to plot roles and responsibilities. And in particular, what you're looking at is the task levels that you can see in the top right corner. So responsible, accountable, consulted, and informed. And what a RACI does is it really allows you to plot and visualize where those accountabilities and responsibilities sit. Now, what you can see from the table that we plotted here with our trustees within Ariva is that a huge amount of the accountability, or all of the accountability, actually sits with our trustees. But when it comes to the responsibility, so the doing, the carrying out of lots of these compliance activities, actually they're very much outside of the control of the trustees. So they're being done by suppliers or processors or your partners within the schemes. What you'll also see is that the group information security team, so the team that I sit within Ariva, there are some responsibilities that we take on as well. So we're delivering some of those activities on behalf of the trustees as well. But ultimately, it's very much the trustees who are accountable. So it's really important that trustees, in your roles as trustees, you've got the confidence in your supply chain and your group information security team and data protection team that those activities are being delivered to an acceptable standard. If you wouldn't mind moving on, David. So in terms of how our team within Ariva are really helping to provide that assurance to our trustees, there are a number of activities which we complete within the business. So the first thing that we're always looking for from suppliers and partners within the pension space is industry certifications. So we're always looking for those professional certifications that really demonstrate that a supplier or a partner has a really good security and data protection posture. And one of those certifications, which I'm sure you'll be familiar with, is known as ISO 27001 or 27002. And it provides a really good level of assurance because it's an independently certified certification. So it really does give you that confidence that an organisation is committed to ongoing compliance activities. The next thing that we're always looking at as well is conducting security assessments. So when we're engaging new suppliers and when the schemes are looking at bringing new suppliers on board, we'll put those suppliers through a security assessment process. So we use what we call an SAQ, and it really allows us to assess the cybersecurity and data protection posture of an organisation. And we do that through a large set of questions which are aligned with industry best practice. So looking at some of those things that are pulled out of ISO 27001, 27002, but also looking at the obligations within data protection legislation as well. The next area is really looking at data protection impact assessments. So all organisations have a statutory obligation to complete DPIAs where there is a high impact to the rights and freedoms of individuals. So again, what we're always looking at is ensuring that we can support the trustees in completing DPIAs where there is a legal need to do so, and ensuring that we can draw out from those DPIAs any risks that exist, and make sure that we're working with trustees to address those risks. And then the final area there is just around contracts. So we're constantly working with our legal colleagues to ensure that any contracts that are entered into on behalf of the trustees provide the right level of contractual protection. So looking at the clauses that are included within those contracts around data protection and cybersecurity. Okay, so the next topic to cover is around subject access requests. David, if you could just move it on to the next screen. So this particular slide isn't designed to kind of scare anybody, but it's really designed to indicate that there is a lot that has to happen within a very short space of time when a subject access request has been received. So you'll all likely be familiar that there is a statutory time period of 1 month for handling a request. And within that period of time, there's lots of things that need to happen, and often many of those things are outside of the control of yourselves as trustees. And that's mainly because it's your suppliers or your partners who are involved in the delivery of the schemes who will be handling those for you. So what we've been doing with our trustees in Ariva is really looking at a process that gives the trustees the confidence that those requests are being handled in line with statutory obligations, but also within that statutory time period. So what you'll see on the screen now is a very simple flow diagram just designed to indicate what that process looks like and how we should expect it to happen in best practice. So it very much starts with the requester. They submit the request. Your partner or your processor will be responsible for actually validating that request and making sure they've got enough information to process it. But in parallel, what we expect to see is that your partner or your processor is actually informing you as trustees. So you've got that early visibility that a request has been received. What you can then see is that the majority of the work is all happening in the processor space. So your supplier is the one going out, commencing the searches and locating the information. And it's only once they've produced a final disclosure bundle that the expectation is they're coming back to our trustees. So the trustees then are very much involved in reviewing that proposed disclosure, making sure that they are comfortable with the response that's being provided. And once the trustees are satisfied, it's then back with the processor and it's their responsibility then to make that disclosure. Once that disclosure has been made, we're then satisfied that that can be closed down by all parties. So that's really just to give you a bit of an indication of the process that we're working with our own trustees on. And one of the really interesting conversations that we've had with our trustees is around that review process. So when it hits the trustees, and it's the trustees' responsibility then to make sure that they're comfortable, what are the sorts of things that they should be looking out for? So we've produced a bit of a checklist to support with that process. And you'll see it on the screen here. So the things that our trustees are starting to look for in these reviews is, firstly, has the requester's identity been confirmed? Are we absolutely certain that we're talking to the right person and making a disclosure to the right person? The next point then is around completeness. So one thing that we're always very conscious of is that lots of requests can be quite complex. So it's really important to make sure that the disclosure actually responds to the request. And in order to help with that review, it's often useful to understand what searches have been conducted by your supplier and what criteria they've used to actually identify that information for the disclosure. The next area is around accuracy. So really making sure that what's in the proposed disclosure relates to the right individual. So making sure there's no errors there and there's not a risk of disclosing information to the wrong individual. The next point is around redaction. It's not always appropriate to carry out redactions, but where it is, the expectation on the trustees is that they've got that visibility of where those redactions have been made and that they're comfortable with those redactions to protect any third-party personal data. And then the last 2 points there are really around the response that goes out to the individual. So the first one is around transparency and really ensuring that that response is clear and it explains to the individual what searches have been conducted and the outputs of those searches. And then finally, that it's very clear in the response that there is an escalation process. So if they're not satisfied, it explains very clearly to the individual what that process looks like for lodging a complaint. Thanks, David. Okay, so finally then, working from home, as David said, you know, it's been an extremely interesting year. Everybody's had to change their ways of working. And what I'm going to talk you through is really just some kind of hints and tips, if you like, that we have been speaking to our own businesses about. So one thing to bear in mind whilst I'm talking through this is that, you know, if you are thinking about any gaps that these might present for your organisation, it's really important that you're working with your own local IT teams, as you may have slightly differing procedures. But the sort of things that we're very conscious of and we're talking to trustees about are things like passwords. So it's really important, if you're being reminded to change a password, that you do it as quickly as you possibly can. And also really important that people are using the strongest possible passwords to protect you know, systems and information. In terms of printing, we do ask people to refrain from printing at home, but you know, there are often times when you may well need to. So if you do need to print anything from home, then make sure that you're doing that in line with your own organisation's policies and procedures. In terms of document disposal, again, you know, we're always advising people to make sure that any physical documentation that they've got is being managed securely. So if you need to get rid of something, make sure that's being done either using confidential waste bins if you're in the office, but if not, if you've got access to a shredder, that's brilliant at home. Some people opt to burn things if you can do so safely, but otherwise store it securely until you can return to the office and actually use a secure method of disposal. The next point there is just around you know, leaving documents at home. And again, we just encourage people to behave the same way at home as they would in the office. So if you're dealing with confidential documents, you know, make sure that you're securing them at the end of your working day, that they're not being left laying around the house. Next slide, please, David. Okay, so just to finish then, sensitive calls, again, you know, just be really cautious if you're taking sensitive or confidential calls, and be aware that people could be listening to that conversation. So just take care when you're doing that outside of the office or working from home. And if you're opting to use a personal device, so it's not a corporately issued laptop or device, then there are some things that we recommend to our own employees and trustees. And that is that we encourage people to use Microsoft Office 365, which is a platform that we provide, and it allows people to log on securely and do things in a secure environment. We do discourage the use of personal email addresses to send company or trustee related information, but again, we completely appreciate that it's not always possible to avoid that. But if so, you know, we do encourage people to use corporately provided email accounts, just because it provides a good level of security. Again, we're encouraging people to lock screens and prevent the disclosure or visibility of confidential information outside of the office. And then there are also things you can do to make sure that your home Wi-Fi is secure. So you can use a VPN to connect, and also you can make sure that your antivirus software is up to date on your computer. But if you're ever concerned about anything like that, then we would always recommend people speak to their local IT teams. And then lastly, just a little tip, because we're very aware that networks can be a little bit intermittent when working from home. So if you've got this autosave functionality on your laptops or on your accounts, it's always beneficial to use that, because if your internet does drop out, you're working on something really important, you can be reassured that your documents are safe when you log back on. Thanks very much, David.
Thank you, Natalie, so much for that. Really helpful and very clear as well. So lots of practical tips there. I'd now like to turn to my colleague Leonie Power, who, as I mentioned at the start, is an information and privacy law specialist, and she's going to talk about how pension schemes can look at cybersecurity from the data protection legislation and the Information Commissioner's Office point of view. Leonie.
Thanks very much, David. Good morning, everybody. As David mentioned, I'm going to focus on GDPR obligations in relation to security of personal data held within pension schemes, and also the obligations on trustees in respect of reporting personal data breaches to data protection authorities. The first general point to make is that, you know, pension schemes obviously consist of very rich personal and financial data sets, which are particularly attractive to cyber criminals. And scheme administrators in particular, given their access to these data sets, are potentially vulnerable to ransomware and other cybersecurity attacks. Now, the GDPR imposes specific obligations in relation to ensuring the security of personal data and also in relation to notifying personal data breaches. So if we look at this slide, we can see generally the types of personal data that are likely to be held within pension schemes. And as I've mentioned, you can see, there's potentially a very rich set of personal data being held within schemes. So from a general personal data perspective, there's things like members' names and addresses, salary information, members' age, bank account details, national insurance numbers. And then within the category of personal data, there may be what's known as pseudonymous data, which is data essentially from which the real world identifiers have been removed. So it might include things like a membership number or a device ID, to the extent that members are using their own devices to, say, access a membership portal. And then within the category of personal data, also there's special category data. Now, special category data, as you may know, is given specific protection under data protection legislation. And that will include things like health data. So, for example, medical reports. And one of the questions actually we often get asked is whether something like marital or civil partnership status data amounts to special category data, insofar as you can infer, for example, sexual orientation. And we would usually say that to the extent that the data is not being used to infer special category data, then it shouldn't be treated as such. That said, in a security context, if a hacker were to get a hold of that type of information, they could make those type of inferences. So again, the risk of what might happen to the individual needs to be taken into consideration in deciding what level of security needs to be applied to the data. And similarly, even though there are some personal data elements that may not come within the special category data, such as bank account information or salary information, because of the sensitive nature of that type of information generally, then that will merit greater security around that particular data set. So let's look at what the GDPR says in particular around security of personal data. And in general, under Article 5 of the GDPR, there's a requirement that personal data be processed in a manner that ensures security of that personal data. And under Article 32 of the GDPR, there's an obligation on both controllers and processors to implement appropriate technical and organizational security measures. So the GDPR isn't prescriptive when it comes to the security measures to be implemented. It's very much a risk assessment, in the same way as David mentioned in the context of pensions regulations in relation to internal controls. And in making that a risk assessment, controllers and processors need to take into consideration the nature, scope, context, and purposes of the processing. So the nature of the data is one of the things to be considered. So if we're dealing with special category data or data of a particularly sensitive nature, then that will trigger the need for greater security. Scope is also relevant, so the volume of the data. And as we know, pension schemes contain huge volumes of personal data, and also the context and purposes of the processing. Another element to be taken into consideration is the state of the art. And what that means essentially is the consensus of professional opinion as to what's appropriate in this particular area. And one of the things recommended, for example, by the pensions regulator is that one of the things that trustees should consider is whether to appoint a cybersecurity risk expert. And doing so may help in terms of establishing the consensus of professional opinion in this area. Or similarly, as Natalie mentioned, using processors, for example, that conform to particular standards is likely to be evidence of taking account of the state of the art in relation to security. Trustees and their processor can also take into consideration the costs of implementation insofar as that's about making good business decisions. And of course, there's the risk to the data subject. So the higher the risk, then the greater the security measures that should be put in place. Now, in a pensions context, security is very likely to involve a coordinated effort across the trustees and the sponsoring employer and the scheme administrator. And ideally, trustees would use, for example, employer IT equipment that's subject to the security protocols applicable within the employer's environment, and would ideally be able to demonstrate that they've signed up to the relevant acceptable use policies and other policies that apply to the use of that equipment. So, for example, not downloading viruses or malicious software, ideally only using employer issued devices to process scheme data, but to the extent that, personal devices may be used, then doing it via some of the methods that Natalie discussed. So having some kind of secure way to access the scheme data. And then, of course, there's security in terms of safe processing by the trustees themselves. And Natalie covered some of that insofar as, she talked about not printing things locally if at all possible, securing, disposing of things in a secure manner, etc. And so it's about ensuring that trustees are given appropriate guidance around security, particularly in a remote context. And as Natalie's slide on this point illustrated, it's, security is not always about technical security. And indeed, the GDPR makes that absolutely clear. It's about technical and organizational measures. And some of those organizational measures involve some basic things, like trying to work paperless where possible, avoiding traveling with hard copy documentation, anonymizing members' names in trustees' papers where you do need to have paper-based documents, and doing the kinds of things that Natalie discussed. I mentioned that there's a statutory obligation both on controllers and processors. So, for example, on the trustees and on the scheme administrator to ensure security. However, it is very much part of the trustees' securities obligation to ensure that they engage scheme administrators and other processors that provide sufficient guarantees in relation to security. And one of the things that GDPR does is that it requires that a written contract is put in place between controllers and processors that contain certain mandatory provisions. And so it would be incumbent on trustees to ensure that contracts with scheme administrators and other processors require the processor to report a personal data breach to the trustees as soon as they become aware of it, and also to assist the trustees with gathering information and doing whatever else is necessary to assist the trustees in complying with their breach notification requirements. Now, there is room for some commercial negotiation around these points insofar as there is a basic requirement to include something about notifying the trustees without undue delay of a personal data breach. But you may want to think about what other things you put into the contract with processors or scheme administrators in terms of the time periods within that should be done, what type of information should be provided to the trustees, and how detailed that should be. Next slide, please, David. Okay, so EU and UK data protection law also have provisions in relation to incident response. So the key provision is in relation to notifying a personal data breach. So not all cybersecurity incidents will necessarily involve the compromise of personal data. It's only where you have a personal data breach as defined that trigger these specific notification requirements to data protection authorities. And the GDPR defines a personal data breach as a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to personal data transmitted, stored, or otherwise processed. And within that concept, actually, of a breach of security leading to these things, there's this concept of a lack of availability of data. And a lot of the times, trustees and data controllers don't necessarily appreciate that there doesn't necessarily have to be loss or unauthorized access to data for there to be a personal data breach. It could be, for example, that a cyber attack leads to the lack of availability of scheme data, such that, for example, payments are unable to be made, or something else that has a significant impact on individuals, and that would also amount to a personal data breach. So what are the obligations then from a GDPR and data protection perspective? Well, there's a dual obligation on trustees. And the first part of that dual obligation is to notify the relevant data protection authority without undue delay and in any event within 72 hours of becoming aware of the breach. And that then immediately begs the question, well, when do the trustees become aware of a breach? And there is some guidance on this from the Article 29 Working Party Group, which is essentially a group consisting of the various supervisory authorities. And it has, in fact, been replaced by the European Data Protection Board. And the EDPB, as they're known, have endorsed this particular guidance from the Article 29 Working Party. But trustees would become aware of the breach when they have a reasonable degree of certainty that there has been a security breach that has led to the compromise of personal data. And once they become aware of the breach, the time starts ticking, essentially. And unfortunately, it doesn't respect holidays or bank holidays or weekends. The 72 hours runs from becoming aware of the breach, regardless of, what day of the week it is. And the only situation in which a delay in reporting is permitted is if there's reasoned justification. And if the trustees do delay in making notification and they subsequently follow up, then they need to provide that reasoned justification along with the notification of the breach. Now, the only situation in which the trustees could decide or can decide not to notify is if they conclude that the personal data breach is unlikely to cause harm to the relevant individuals. And so that involves some kind of a risk assessment. And we'll talk shortly about how controllers might go about assessing risk in this particular context. The other part of the trustees' dual notification obligation is to notify members in certain circumstances. So to notify the data subjects who have been affected by the personal data breach. And that notification obligation is triggered if there is likely to be high risk to the rights and freedoms of the relevant individuals. And the notification in that situation in terms of timing must be made without undue delay. Now, there are a number of exemptions in this particular context. One exemption is if the data is unintelligible by virtue of measures taken before the breach. So that might be, for example, a highly encrypted laptop gets left in a taxi. If the encryption is at a level that it would be very difficult or impossible to, reverse engineer that encryption so that effectively the data is unintelligible, that would exempt the trustees in that situation from making the notification to individuals. Then the other exemption is if the high risk has been negated by measures taken after the breach. So in other words, you've done something immediately to negate that high risk to the individuals. And the third exemption is if it would be disproportionate effort to notify the affected data subjects. And that might be, for example, in a scenario where there was many, many thousands of data subjects affected, and for example, the controller didn't have their contact details. It's probably unlikely in a trustee scenario that trustees would be able to rely on the disproportionate effort exemption, because generally they will have good oversight of all of the members within the scheme and the contact details for those members. In any event, in order to avail of the disproportionate effort exemption, a controller would still need to publish a notice that they've suffered breach, which it isn't a very attractive proposition, having to put something public out there that you have suffered the breach in order to bring this to the attention of the relevant individuals. So that sorry, David, there's just one more point on that previous slide. So that's the dual obligation to that's on trustees. There's also a statutory obligation on processors, and so the processors to the trustees, so that would include, for example, the scheme administrators and other processors, and their duty is to notify the trustees of a personal data breach without undue delay from the time that they become aware of the breach. And so that's a specific statutory obligation on processors. And as we've already mentioned, it's also something that needs to go into the contract between the trustees and the scheme administrator or other processors whereby an obligation is imposed on those processors to notify the trustees of personal data breach without undue delay. Now, all of this effectively means in practice that the trustees should be careful to have in place an appropriate incident response plan in order to deal with incidents and to enable the scheme to swiftly and safely resume operations. And that incident response policy should cover all potential notification obligations. I mean, we're focusing here on data protection notification obligations, but there may well be other notification obligations, such as to the pensions regulator in certain circumstances, perhaps to the Financial Conduct Authority in other circumstances. And from a trustee's perspective, again, it's likely to be a coordinated effort in this particular context. And it's important from a trustee's perspective that they understand the third-party supplier's incident response processes. Because the incident response is very likely to involve the IT teams of the scheme administrator and or the sponsoring employer and the trustees working together to understand the implications of the breach. And this is very much an area where support from the sponsoring employer in terms of, tying in with the employer's data breach procedures may be particularly helpful. And ideally, there would be some kind of breach investigation team, a breach investigation team coordinator who would organize the team calls and meetings, who would check progress against actions, who would facilitate lessons learned sessions and update the incident response policy as needed. Now, it's really important in this context to test. In other words, conduct data breach exercises using sample scenarios to test the data breach procedures and to familiarize the trustees and key individuals with their role in the event of a breach. And this slide then shows some examples of cybersecurity incidents that may affect pension schemes. And as I've mentioned, not all of these will necessarily involve personal data breaches. It's only to the extent that they involve personal data breaches that the notification obligations that I've just discussed are triggered. But in many cases they will, particularly if you take into consideration that if the breach results in a lack of availability of data, that is also a personal data breach. So examples include, obviously hacking into computer systems of trustees or administrators, viruses or malware being introduced. Sometimes it can just be simple human error, sending member data to the wrong email addresses, computing devices being lost or stolen. So we mentioned the laptop in the taxi, a loss of availability of personal data we've mentioned, and altering personal data without somebody's permission, are all examples of cybersecurity incidents which may or may not involve personal data breaches. So we've mentioned that one of the scenarios in which a trustee does not have to notify the Data Protection Authority is if there is unlikely to be risk to the rights and freedoms of individuals. So if there is a personal data breach, then the starting point is the trustees must notify that breach to the Data Protection Authority without undue delay in any event within 72 hours. They don't have to do that if they conclude that there is unlikely to be risk. So what do we mean by risk? Well, it could be the risk of discrimination based, for example, on sexual orientation or on ill health, some kind of identity theft by virtue of getting hold of bank account details and national ID, etc., fraud or financial loss of some kind, or damage to reputation, loss of confidentiality of personal data that's being protected, for example, by professional secrecy, let's say in a doctor-patient scenario, reversal of pseudonymization in an unauthorized manner, or some other kind of significant or economic social disadvantage. So then assessing risk will involve assessing the severity of the risk, and that will involve assessing, for example, whether there's likely to be physical harm or some kind of psychological harm. And damage is more likely to occur if, for example, it involves special category personal data, because there we're dealing with things like health data or data around religious belief or data about sexual orientation. And generally speaking, that type of data involves an inherently greater risk to the extent that it falls into the wrong hands. The nature of the breach will be relevant, so there will be a different risk profile for data that's lost as opposed to data that's stolen, where there's some kind of a malicious intent. And as I've said, the higher the sensitivity of the data, the greater the likelihood of harm. Or you may have innocuous data being combined with other data, which makes for a more sensitive data set. So the volume of data will also be relevant, as well as the ease with which individuals can be identified. And obviously the vulnerability of particular individuals will also be a factor. The special characteristics of the controller. So in this case, the fact that it's a pension scheme and likely to be, rich with particular types of data and likely to be the target of attack by cyber criminals, is a factor to be considered. So assessing risk then in more detail. Again, the GDPR is not prescriptive in terms of how to assess a risk. Recital 85 of the GDPR does provide some examples of potential physical or material or non-material risk, but it doesn't go into any useful detail about how such a risk assessment should be carried out. And for this, we can potentially turn to the guidance from ENISA. And the ENISA is essentially a centre for network and information security expertise for the EU and its member states and the private sector and Europe's citizens. And it works with these groups to develop advice and recommendations on good practice in information security. And when the European Data Protection Board published their guidance on breach notification, they referred out to this ENISA guidance. It's worth saying it is from 2013, so it does predate the GDPR. However, it can be used as a useful tool for reaching a sound conclusion and also for documenting the fact that you've taken a particular decision, for example, a decision not to notify the relevant data protection authority. Next slide, please, David. Thank you. So in terms of the ENISA formula, essentially it's based it's a formula for the severity of an incident. So the severity of an incident is given a particular score, and the severity of the incident is essentially a function of the data processing context, the DPC, the ease of identification, the EI, plus the circumstances of the breach. Sorry, David, if you wouldn't mind just going back to the previous slide. Thanks. The main criteria to be taken into account when assessing the severity, as we've said, are the data protection context, so the DPC. And what we mean there is, again, the type of breach data, together with a number of other factors which are linked to the overall context of the processing. And then we've got the EI, the ease of identification, which determines how easily the identity of the individuals can be deduced. And finally, the circumstances of the breach. Does it involve some kind of malicious intent? Next slide, please. Thank you. And that will then, having gone through that formula, you will end up with some kind of a risk rating. And that risk rating will be low, medium, high, or very high. And that will then give you an indicator of whether notification to the regulator and or the affected individuals will be required. Now, the overall point to make here is that this formula is a guide. So it's not exact. So sometimes in practice, you'll need to inject a bit of common sense and pragmatism into it. But that said, it's a helpful tool if you need to, and in fact, you do always need to document your decision-making process as to whether or not to notify. Next slide, please. So then just to wrap up with some key questions to ask in this particular context. Have you considered as trustees the need to appoint a cyber risk expert? Have you included cybersecurity as a key risk on the risk register? Have the trustees taken cybersecurity training? Are your measures up to scratch and do you review them? And do you review risk mitigation steps taken by individual trustees? As Natalie mentioned, it's very important to conduct pre-contractual due diligence in relation to service providers, and that also extends to making sure that they're doing what they're supposed to be doing post-contract. And then looking at your contracts with processors in general to ensure that there's appropriate obligations around breach notification and assisting the trustees with information gathering, making sure you have an incident response plan and making sure that you test that plan, having a plan for communicating breaches to affected members. Will you offer, for example, identity theft or credit monitoring services? And an obligation to keep a record of the breaches. So making sure you have some kind of an incident log in which you record the decision to notify or not to notify. And so they just some practical steps in that regard. Thank you.
Thank you so much, Leonie. If anyone's fast at typing and has got a question, then please do submit it through the questions function. This is the last call for questions. We've got one, if I can just throw it at Natalie, because I think you're probably best placed to answer it, which is looking at the way in which the 72 hours doesn't take account of bank holidays or public holidays. How are things going with plans for Christmas and New Year? How does that work for you at Ariva?
Yeah, really good question. I mean, we're quite lucky in Ariva because we have a group IT team who are 24/7, 365 days of the year, given the nature of our business. So in terms of our incident reporting process, provided things are flagged following the procedure we've got internally, we've got a really good call out procedure. So as soon as our IT team are notified, they'll actually make contact with our team. And so you're absolutely right, that could be late at night, late on a Friday night, it could be at some point over the weekend. And we could even find that we're getting that call out on Christmas Day, depending on the severity. So really good question. I think it's just really important to ensure that you've got those escalation and reporting processes internally that will facilitate, that kind of call out process.
Okay, well, I really hope you don't have to test those processes, but it's good to know for you that you've got them there. So thank you everyone for joining today's session on cybersecurity essentials for pension schemes. I hope you found it useful. All of our webinars, not just the pensions ones, but all across the firm, are recorded and can be found on the Field Fisher YouTube channel after the event. If you have any questions that weren't answered, then please do follow up with us. On this slide, I've just got a brief trailer for the future webinars that we've got. We thought we wouldn't do one in the first week in January. Unlike Natalie's team, we are taking a little bit of a break at Christmas and New Year. But we will be coming back looking at the financial pressures on employers and how pension schemes might need to deal with those. And then later in March, Andrew Patton from our pensions group will be talking about governance and 21st century trusteeship, both with guest speakers, firstly with Dan Mindell and Nick Gibson from Lincoln, and secondly with Grant Sunklean from Ross Trustees. I'll just leave up my contact details and Leonie's if you do have any questions and you want to follow up with those. But finally, just keep safe, and we hope you can join us again in 2021. So thank you, everyone.